So let's turn now to the ruling of the Unified Patent Court, the Court of Appeal, to be more precise, of the Unified Patent Court, in a dispute between Keeex as the claimant and Adobe, OpenAI, and others as the defendants. As I mentioned already, this is a dispute which revolves until now around this one specific question of jurisdiction, and particularly the so-called long-arm jurisdiction of the UPC. In other words, the question of whether the UPC can assume jurisdiction, can decide cases in which the infringement of patents that have been granted and are enforced in other jurisdiction outside of the UPC territory is the subject matter of. This is exactly what was the case here. So we had proceedings initiated by Keeex against Adobe, OpenAI, and other companies. In total, it was 8 companies that have been sued here. Maybe just one brief note, this was not a case that referred to an SCP, but nevertheless, the principles that have been laid down here would equally apply for SCPs as well. So that's why it's a very interesting decision that needs our attention. So the lawsuit was filed by Keeex before the local division of Paris of the UPC. And it was primarily around damages. So Keeex wanted to have damages for the infringement of its patents within the UPC territory. And this is the interesting additional element here, for the infringement of its patent, its European patent, in Switzerland, Spain, UK, Ireland, Norway, and Poland. All of them non-UPC countries. So the proceedings were directed to damages within UPC territory and also outside UPC territory. And this is exactly the element of the long-arm jurisdiction we have discussed before. So here, the part of the proceedings was remedies, damages for infringement of the patent, of the national designations of the patents outside of UPC territory. The parties, the defendants, all contested the jurisdiction of the court. So we had first the court to decide whether it has jurisdiction or not, and the local division in Paris did that in November 2025, confirming jurisdiction also for the non-UPC countries. This decision was then appealed by the defendants shortly after it was delivered, and with the present ruling from March this year, the UPC Court of Appeal found in favor of the defendants by rejecting jurisdiction for infringements outside of the UPC territory as far as damages are concerned. So this is the status quo in these proceedings for now. And let's try to locate here the exact questions that were posed to the court. So when I said that the claimants contested, the defendants contested the jurisdiction of the court, I meant that they contested the jurisdiction for alleged infringements only outside of the UPC territory. So within UPC territory, the jurisdiction of the UPC was not contested. So this is clear that the UPC can go on with that case, but it was contested for the other countries. And here we have 2 different types of countries. We have, on the one hand, EU member states that are not part of the UPC system. In our case here, it was Spain, Ireland, and Poland. And we have also non-EU member states, which of course are also not part of the UPC system. In that case here, UK, Norway, and Switzerland. So this is the one link, let's say, which leads us outside of the UPC territory. The second one, however, which is very important here, and we should keep in mind, is that none of the defendants was actually domiciled within UPC territory. So what we had here, and this is a very significant element of this case, is that all defendants, all 8 defendants, were either based in the US. If I remember correctly, 6 of them were based in the US, and the rest of them was based in Ireland, which is EU but non-UPC. Again, none of them was based in UPC territory. So the question was here, can the court assume jurisdiction, long-arm jurisdiction, against defendants that are not domiciled within UPC territory for the infringement of patents that have been granted and are in force again outside of the UPC territory? And the answer of the court here was a clear no, as we said. I just copied here the 3 provisions that were relevant for this decision. We have provisions from the Brussels I regulation, which is a new regulation that applies also for the UPC when it comes to the question of jurisdiction and international jurisdiction. And we have one provision, it's Article 4, which lays down, let's say, the general rule that any party which is domiciled within UPC territory can be sued before the UPC, irrespective of its nationality. So this is the general rule. But there are some special rules as well, which can create the jurisdiction of the UPC, even if you don't have someone domiciled in the specific member state. For example, you have Article 7.2, where you can create jurisdiction of a court of the UPC for matters relating to tort or delict, etc., which would include also damages for patent infringement, in the place where the court sits where the harmful event occurred or may occur, which in the context of patents would be the place where infringement occurred or may occur. So this is a special rule that might also be used to create jurisdiction of the UPC. And there is a third rule that might also be relevant. It's Article 71B of the Brussels I regulation, paragraph 3 there, which also creates the possibility for a court that has been seized with the infringement, with a case around the infringement of a European patent that gives rise to damages within the UPC territory, to expand this jurisdiction also with respect to damages arising outside of this territory. However, here there are 2 conditions that need to be met. First of all, there should be a sufficient connection with the UPC territory. And the second one, the defendant should have property within the UPC territory in order for this provision to be triggered. So these are the 3 possibilities that we had here for for the UPC assuming jurisdiction for the non-UPC part of the infringement action, and none of these options was applicable here. Article 4 was not applicable clearly because none of the defendants, as I said already, were domiciled within the UPC territory. And again, this provision really opens up the jurisdiction of the UPC if the party is domiciled within the UPC territory. So this was not the case here. Article 4 was not applicable. Then Article 7.2 create the jurisdiction in the place of the court where the infringement occurred or may occur. This was not applicable here either, because the UPC noted that also according to the case law of the Court of Justice of the EU, this provision establishes jurisdictions only for damages that occurred within the territory of the court. So you can attract, let's say, jurisdiction even eventually for a defendant that is domiciled outside of the jurisdiction of the UPC, but only as far as damages that occurred or might occur within the UPC territory. So this does not apply to the long arm part that we discussed already, because these are exactly damages that occurred or might occur outside of the UPC territory. So the last option available here would be Article 71B, and this was also not applied here because the UPC found that the claimant Keeex had not managed to provide proper explanation and did not really plead the facts that would allow the court to assume jurisdiction based on this provision. And the main point of criticism was that it did not really offer any sufficient substantiation around the question of whether each of these defendants here, which were all not based within UPC territory, had property within the UPC territory as requested here by this provision. So also with respect to Article 71B, there was no possibility to establish the jurisdiction of the UPC here in the present case. So maybe to sum it up, what the court said here in these proceedings is that in cases where you have defendants that are not domiciled within UPC territory, it is rather difficult and challenging to create jurisdiction for the UPC. When it comes to long arm cases, meaning cases where the potential infringement is based on patents that are in force outside of the UPC territory. So in these cases where you have defendants not domiciled within UPC territory and the infringement is outside UPC territory as well, it will be difficult to expand the long arm jurisdiction of the UPC and also allow the court to rule on these specific issues as well.